Terry Knowles, who's going to be joining us via Skype from New Hampshire, and will also be able to answer questions just as Marion was, is in the New Hampshire Attorney General's office, and she has held the position of Assistant Director of Charitable Trusts in that office for the past 32 years. And as part of her work, she co-authored in collaboration with the New Hampshire Land Trust community a guide pertaining to the amendment and termination of easements. She's a frequent presenter on nonprofit issues, most recently at Harvard University, their seminar on emerging issues in philanthropy, and at Columbia Law School, a webinar on endowment management.
I want to thank you for inviting me here today to present on the role of the Attorney General in New Hampshire in the amending, termination, and condemnation of conservation easements. It's also my pleasure to be co-presenting with my colleague Mark Pasella from Pennsylvania. New Hampshire's experience is not unique. Several years ago, Attorney General Kelly Ayotte, now U.S. Senator, took the position that conservation easements are valid charitable trusts. This means that easements held by nonprofit charitable organizations are subject to donor intent and enforceable by the Attorney General. Following the issuance of that opinion, the Attorney General's office worked with the Society for the Protection of New Hampshire Forests and with Professor Nancy McLaughlin in authoring a guide to amending or terminating conservation easements, and this is the guide that we produced. The guide creates a procedure for easement holders to follow in those cases where a change to or an extinguishment of an easement is necessary. The guide creates 3 categories of review: low-risk amendments, more-risk amendments, and high-risk amendments. This process requires the seeker to submit to the Attorney General's office a letter describing the requested change, including all necessary documentation and a plan that shows the proposed change, as well as an explanation of how the proposed amendment will address the 7 principles contained in the guide. The 7 principles include the following. First of all, the change must clearly serve the public interest and be consistent with the easement holder's mission. Number 2, it has to comply with all applicable state, federal, and local laws. Number 3, it cannot jeopardize the easement holder's tax-exempt status under either state or federal law. It cannot result in private inurement or confer an impermissible private benefit. The change must be consistent with the conservation purposes and intent of the easement. It also must be consistent with the documented intent of the donor, grantor, and any direct funding source. And finally, the change must have a beneficial, neutral effect on the relevant conservation values or attributes protected by the easement. So let's talk about the 3 levels. The first one is the low risk. This usually involves a scrivener's error, a boundary line correction, or a transaction which does not diminish the conservation easement in any way. Generally, after review, the Attorney General will issue a no-action letter in these situations. An example of a low-risk amendment is the following case. The abutting property owner to a conserved easement parcel surveys his property and discovers that there may be a boundaries dispute between the 2 parcels. The easement holder then engages the service of a surveyor, and the resulting plan indeed does show an error was made in the original survey. In this case, the amendment is low risk. A mistake has occurred, and the easement holder wants to correct the boundary line. After review, in this case, the Attorney General issued a no-action letter. Medium risk are more difficult because, number 1, they require a greater degree of review by the Attorney General, and they must be analyzed in detail to determine whether or not this type of action is going to require a filing in court. In this situation, the change may affect the conservation purpose either positively or negatively, may involve private inurement as defined by the Internal Revenue Service, may not be consistent with the mission of the easement holder, It may also give rise to objection by the grantor, his or her heirs, or neighbors who may be concerned about the change. In a medium risk amendment, the Attorney General will review all material and determine, 1, whether the charitable trust issue exists in this particular transaction. Number 2, if there is a charitable trust issue, whether the transaction meets the 7 principles. And 3, whether court intervention will be necessary. If the proposed change is extremely complex, we do require that the seeker have a meeting with the Attorney General. Here's an example. Conservation easement on a 200-acre parcel reserves 2 house lots in specific locations near the eastern boundary of the conserved property. The abutting property owner, to the east, subdivides and develops his property, resulting in the construction of 25 house lots. The owners of the underlying fee in the conserved property want to relocate their reserved right in order to get away from the subdivision. They are willing to extinguish one of the house lots in exchange for the relocation of this reserved rights. In this case, an appraisal was conducted at the owner's expense to determine whether the swap of locations and the extinguishment of the second house lot were of equal or greater value. Number 2, both a certified public accountant and an attorney reviewed the transaction to see whether or not there would be a private inurement or private benefit issue. And 3, an examination was undertaken to see whether the conservation value of the land would be diminished by this change. In the final analysis, it was determined that the conserved value of the land would actually be enhanced by the extinguishment of the second house lot, and that the proposed location would not adversely affect the conservation purposes of the parcel. The appraisal and the evaluation of the CPA concluded there was no private benefit. The Attorney General determined it was not necessary to go to court and assented to the proposed change. The third process is the high-risk amendment. This generally involves the release of restrictions, the removal of land from the easement, or an outright extinguishment. Because these are complicated transactions, the Attorney General needs sufficient time to review and analyze all aspects of the proposal. A face-to-face meeting is required in all high-risk transactions. High-risk amendments generally require approval by the probate court under a petition for cypre or deviation, and the Attorney General is a necessary party to these cases. A complete set of documents, plans, and other information must be submitted for review. Appraisals and other supporting documentation is required in nearly all cases. An example of a high-risk amendment is follows. A land trust charity holds an old easement on a 500-acre parcel of land. 2 individuals hold title to the underlying fee. The parcel is bisected by a town road, resulting in 2 parcels being separated from the main parcel. One of these parcels is a 2-acre piece. When the underlying fee owner passes away, he leaves his property to his children. The children sell one of the 2-acre parcels to a third party, but fail to reference the easement in the deed. The new owner builds a house on these 2 acres. The conservation holder, in reviewing its records, discovers the problem. A high-risk amendment involving an extinguishment of the easement on the 2 acres is requested. First of all, the requester has to go through the 7 principles, as I mentioned before. Appraisals are necessary, and it is necessary to engage the services of a certified public accountant and an attorney. In this case, it was submitted to court under the doctrine of cypre, and the court did grant the request because, after analysis, the 2 acres did not have a significant conservation value, and there was no private inurement. Keep in mind, under the doctrine of cypre, what you need to determine for the court is it's impossible, impractical, or illegal to continue to carry out the wishes of the donor. In applying the doctrine of cypre, whatever is done has to be as near as possible to the original intent. So the underlying owner of the 2-acre parcel paid the appraised value amount to the easement holder, and the easement holder will use this money to monitor the easement on the remainder of the land. This prevents many opportunities and challenges. While our Attorney General and several others hold the opinion that conservation easements are valid charitable trusts, not everyone agrees. There's no doubt that Attorneys General will face legal challenges to their standing in the amendment or enforcement of conservation easements. And we've seen some examples of this in the states of Maryland and especially in the state of Wyoming. Moving along to municipal easements and gifts to towns and cities, these present a particular challenge. Number one, you need to determine how the town or city came to be in possession of the easement. Was this an easement that was given by a donor? Or did the town receive this as a result of a subdivision or other land transaction? Because remember, the Attorney General has to determine whether or not there is a charitable trust issue here, and there may not be in the municipal easement. If there is a charitable trust, of course, the Attorney General would take a look at amending or possibly extinguishing the easement if that was necessary. But the Attorney General may also have a role in enforcing the easement, because it's been our experience that many towns and cities in New Hampshire are easement holders, but they are not aware that they do have to enforce these easements, which will cost them money because they would have to hire an attorney. And that can be a very difficult situation for these revenue-strapped municipalities, so keep that in mind. The Attorney General does not have a large role in the condemnation of an easement. Condemnations have been addressed by Nancy McLaughlin in an article that she wrote on the topic. But in general, the complete or partial condemnation of a conservation easement does not fall under either the low, medium, or high risk categories of the guidelines. The Attorney General's primary responsibility is to understand how the proceeds from the condemnation are going to be redirected. The funds received by the Land Preservation Organization representing the conversion of the asset from real estate to cash still has to honor the donor's intent. So in some cases, it may be necessary to go to the court under a petition of cypre to redirect any money that's received after a condemnation. Finally, one of the particular issues that we've been dealing with is that of orphan easements. And an orphan easement is a situation where the easement holding entity has gone out of existence, leaving no one to take possession of these easements once that charity no longer exists. This can be a problem when there are neither successors in fee to these entities, nor is there any money to monitor the easement. And we have such a situation in New Hampshire involving an organization that went out of existence, leaving absolutely no money to monitor the easements, nor did this organization have any dissolution provision that would send these easements to another easement holder. We have situations in 5 separate towns. Some of these easements really are not worth much money. So we're now in the process of asking the towns and cities whether they're willing to take over these easements. If they're not, we're going to need to proceed to probate court. But again, in the future, I expect to see more and more of these situations arise. So what's the takeaway if you're going to be dealing with an Attorney General in the amendment or the extinguishment of conservation easement? Well, number one, allow sufficient time for the Attorney General's office to review material. Keep in mind this is not the only responsibility that AGs have. Number two, include all facts and pertinent documentation. The more complete the material, the quicker the review will take place. And finally, a telephone call or a brief letter outlining the issue may be submitted to the Attorney General before the process begins. Again, thank you for inviting me here today. And when Mark finishes his remarks, I'll be available for questions.